Good evening and welcome to the February meeting of the Development Review Board for the town of Richmond. For anybody in the audience, whether you're remote or in person, please, please sign the board in the back. And remote, they
Go down on the chat. I think we only have one other person, but they did that. But if anybody is joining us late, please go ahead and go down into the chat and please leave your name, address, and item that you're interested in. If you don't do that, I won't be able to mail you copies of the decision, and it'll be hard for me to add you to the minutes as well. So I'll do my best, but please try and do that.
And for everybody, if you care to be an interested party, as that's defined in Vermont statutes, which would give you the right to appeal any decision we make or not make, you need to offer evidence and speak up, whether it be in writing or orally at the meeting. So on the agenda, first thing is SUB 2025-02, Matt Parisi. Project location is 112 and 114 East Main Street. The applicant is seeking final approval for a proposed three lot residential plan unit development, with lot 1 containing a pre-existing duplex, lot 2 containing a pre-existing single family home, and lot 3 would be common land. Does anybody on the board have conflict that would ask them to?
Yes. I have a conflict.
What is your conflict?
I am the applicant.
Fine,
That's
so
a good
you'll
one.
recuse yourself?
I recuse myself, yes.
Recused. What would you like pulled up, Matt, first?
Well, let me swear Matt in first. And are you gentlemen gonna give any evidence? Nope. Matt, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
What you got in mind here, Matt?
So let's bring up the plat first.
Second.
Full screen that.
Yeah, I'm trying to.
Yeah, no problem. Sorry.
I need like a jumbo monitor to manage.
Yeah,
all
they need to
these
get a
different
bigger one.
things. Trying to keep this up so that way I can respond to it if needed. Is that good, Matt?
Yep, that's good for me as long as everyone else can see. So essentially, just like the preliminary meeting, we are just looking to separate the ownership of essentially unit number 2 into my name and my wife's name. Currently, 112 East Main Street is owned commonly between my wife, myself, and a trust. So we are just looking to separate that out. Kind of went through all the things from the previous meeting regarding some questions. I don't know if we want to bring that up or if there are any questions about the plat currently. If there's any questions from the board on that.
Why don't you finish and then we'll.
Sounds good. So I guess some things for recommendations from the board last time on the preliminary meeting, and Tyler was one of them was a letter from the fire department on how they would access the property in the event of a fire.
Hang on 1 second.
Right there, yeah.
It's not particularly a large email, but that is what we have.
Yeah, so yeah, Dennis,
It's pretty typical of what we're getting from the fire department.
yeah, I had to kind of go to his office and ask him to
And
send
goad
it.
them into it.
But basically, he said it's not easy to get down that driveway, but he can get to it from 98 East Main Street. Very large parking lot next door. In the event of a fire, that's what they would do. So that took care of that. What were some other things? Oh, there was a letter required from the engineer.
Yep.
You got that. Basically confirming everything met all the infrastructure requirements of the town of Richmond and or state, depending on what the requirements were. So there's that. And then
You want me to pull something else up now?
I'm just trying to think if there was anything else on there. We kind of went through all of this already.
Covenants, you didn't have. did you have
No, oh
covenants?
yeah, so you can look at the Declaration of Covenants. Yep, that's a good one. So we can go through that. It's again, we had to go through the whole PUD process just to separate the ownership of the house in the back, but it's pretty basic. It lists the common elements and the non-common elements and the rights of way and the easements, which are all they're all on the plat and site plan as well, and they're just listed in here as well, essentially. There's no budget set up or anything like that yet because everything is still being maintained in ownership by basically myself and the trust. So I don't know.
No, I
you wanna read
I looked it over and it looked fine to me.
Okay,
I did also.
okay. That's really, I think, all there was on the for notes really, other than that. That was required last time.
Let's see here.
Any questions from the board of the applicant?
I was just gonna pick up some of the things that was in the staff report.
Yeah.
I'm trying to get it in front of me. Give me a second.
Yep.
Can I ask one real quick while you're doing that?
Yeah,
Please
you-
do.
There were some notes about the landscaping plan,
Right,
and it's a little bit of a weird one because it's an existing.
right, yeah.
Existing structures and some, old existing properties. So,
Why don't we go back to the plat there?
Yeah.
Or actually, maybe the master development plan, that probably has more of the, not the, yeah, sorry, the 1E.
1E, gotcha,
Yeah.
sorry. I try to keep the labeling the same.
Yeah, so that one has more detail regarding the site. So we've kind of discussed this at the last meeting and there wasn't essentially any extra landscaping done, but there was nothing removed. And there was some concern about in the parking area, if there was going to be screening from like the headlights. And there's, as you can see on the western boundary there, there's a large, oh God, what are they? It's a large bush, lilacs, thank you. Right there that are on the western border. And then there's also a bunch of apple trees and a big maple tree that also provide pretty good screening. And then on the eastern border, Linda's property there's a bunch of birch trees and cedar trees. And then there's also a 6-foot fence in place. So screening from like headlights in the driveway is done pretty well. In that regard, especially on the eastern side, because that fence runs the entire length of the property. And then
What's the material of the fence?
it's an old cedar fence.
Cedar fence,
Yeah.
but it's solid.
And no, it's gonna, I mean, at some point, her and I, Linda, have I discussed about replacing it, just kind of discussing, it's her fence that I'm obviously gonna be paying for, like,
It's on
what
her
she wants.
property.
Yeah, it's on her property, what we
Is
want.
it over 6 feet? I think it is in a couple
It's,
spots.
well, it could be, yeah. But yeah, so that's the fence there, so. But additional screening, no, there wasn't really any additional screening that was proposed in this plan.
Have you discussed screening with any neighbors? Have they expressed any?
Nobody else has expressed honestly any interest for any additional screening. So I mean, we had these discussions earlier with the other neighbors and none of them seemed to really care one way or the other. The biggest concern, which I think is one we've dealt with, was water mitigation, stormwater mitigation specifically. First off, the house has gutters the full length, and the gutters go to underground dry wells. For the long side of the roof there, which is 55 feet long, it goes underground to a dry well over in the corner of the property there where you can see it. And that's about, it's 12 by 12 by about 10 feet deep. It goes all the way down to the sand layer. And that's done really well the last storms we've had. The only storm where there was an issue of puddling of water in the southwest portion of the property there was during the storm in July. That was another 4 inches of rain, so to speak. And then on the eastern side there's a smaller dry well that is right there. And there's obviously gutters on that side of the building. And then there's what you can't really see on this plat, unfortunately, or on this site plan, unfortunately, is that there's two gentle swales that both direct the water on the boundary lines of the property into those dry wells as well. And then between Danielle's property and my property, there's like a swale there as well. It kind of ditches into the middle between the two properties. So that was kind of the biggest concern from all the neighbors. And then Jason, actually next door, you can't really see, it's kind of his kitty corner over there. That's where a lot of the puddling was. And we're actually redoing his garage and kind of deal with some water issues when we do that, actually. So.
So Matt, if I understand this right, the building that you recently built, is it now occupied?
Yeah, I've been living in it since June.
Okay, and all these things were permitted, so basically what you're doing is creating a PUD and taking these individual units and putting them into the hierarchy required to qualify as a PUD.
Right, exactly. Just because since my wife and I basically spent all the money to build this complete house ourselves, we wanted to separate it out from the trust, which is a family trust, in order to,
Well, I understand, and
Yeah.
I just want to make sure that the big picture is clear, that we're not creating anything new here. We're just horning this subdivision into the PUD rules.
exactly.
And
Yeah, it's the
making
only
sure
way to
it's
separate ownership of units
I get it.
in the town of Richmond.
Basically just drawing lines.
Exactly, I see.
And the reason for that, this is one of a very weird characteristic of this particular district, is that it's the only district that allows two principal residential structures on a lot that without having to go through the PUD process. Matt was the guinea pig for this, and to date is been the only person that has availed themselves of this particular thing. I mean, it was a bit of a learning experience for all of us. There's
Yeah.
some weird stuff about this particular district. That's where we found out about the privacy stuff for multifamily housing
Housing
and
standards.
all that stuff was kind of came into play here. So there is, so that's why he was able to do this the first time without having to get it reviewed, because it was a permitted use. All he had to do was get a zoning permit.
When it was all one lot.
Yes, when it was one lot, yes.
Okay.
Let me see here.
Any other questions from the board?
No.
Do we have questions from the,
There are some comments in the chat here. I can just leave them posted for you guys to read real quick. Although I think it is Danielle, if you want Danielle to ask, she can unmute herself and provide any comments if she would like to.
sure. Danielle, do you have anything you'd like to say?
Just to clarify, just because I just was curious if there were new changes to just kind of Richmond rules or zoning that have kind of aligned with the board's kind of change in support of a request like this, just because next door we tried to do the same thing not that long ago. And again, my father was going to be the owner of half and I was going to be the owner of the other half. We had lawyers approve everything. And at the last step, it was not approved. So again, it's all good if things are different, but we had a similar thing. The buildings were already existing. I was not planning to buy two properties at one time as my first purchase. But then I went all in because it was all or nothing at that point. And I had done a lot of the building myself and my dad. So again, just to clarify, just for me to understand, because again, this is not my specialty. I'm a mental health counselor, but I'm also a landowner and just trying to understand if there's been a shift that suddenly, there would just be full support for this when, other people have made similar requests in the past to the board.
Tyler, you think you could offer some?
I'll take a stab
Thank
at
you.
it. And again, it's difficult for me to really speak to the specifics of your project since it predates me and I'm not aware of all necessarily the facts of the matter. What I can say is there has been quite a few changes to this particular area over the number of years. This is the Village Residential Commercial District, VRC. Again, one of the things when this district was created is it does allow two principal residential structures to be located on one lot as a permitted use. That doesn't require approval by the Development Review Board. In addition, due to the changes in Act 181 in the Home Act, any property that is served by municipal water and sewer is by rights allowed up to 4 units of housing inside of one building. I can't treat 4 units of housing any differently than I would a single unit of housing. So if you have 2 principal structures on a lot, each one of those is by rights allowed 4 units. You could have, in theory, up to 8 units on one lot without having to do any subdivision or anything. Now, you could still go through the PUD process. There's other things that you can do. But yes, this is one of the areas that, you know, both through changes at the state level, also those changes have been kind of codified a little bit in some updates to our regs to allow more density in areas that are served by water and sewer. So I don't know if that specifically answers your question, Danielle, but I believe that's why.
Help answer it too. Danielle, I can also help answer it as well if you want.
And again, just looking for understanding again. The buildings are already there. It is what it is, but just trying to understand because there's been a lot of changes and, you know,
Danielle,
we
what
just,
were you trying to do that you weren't allowed to do?
say that again. And again, I don't want to make this about the past situation, just trying to understand if there've been just
I think I know
significant
because
shifts.
we're all involved. We bought the building in the front from Don. Previous to this, obviously.
Yeah, and again, like
So
we
changed.
went to,
Yeah, so they changed recently in June of 23, 24.
Yeah, because you
Yeah,
did
June-
it pretty soon right after it got passed.
June of 24, 2024, Danielle, they changed the residential commercial. And there was a lot of changes, but specifically probably the biggest one was the unit density. So it used to be 1 unit per 10,000 square feet. And now it's 1 unit per 5,000 square feet. When you and your dad wanted to turn that old duplex or bulldoze it, the one we bought from you guys, down, it was, I believe it was still 1 unit per 10,000 square feet. So the lot wasn't big enough for 4 units on that. And the state hadn't passed, I always want to call it S100, but now it's, what is it called?
It's
Act.
it's the Home Act is one acronym.
Yeah.
It's one of, there's 2 of them. It's the Home Act and Act 181 are the
Yeah,
2.
so the
or
state
2.
also passed new regulations last summer,
Yeah,
fall, whatever
they
it was.
they took effect. A lot of them started to take effect
Right.
last year. Now they're fully in effect.
So a lot of these zoning changes, both townwide and statewide, took effect within the past year, basically.
yeah, and again, that's all fair, and that helps to understand. It's just, you know, I'm, you know, yeah, it just
Well,
feels
Danielle, if
like,
you ever wanted to wanted to consider that project, it's something that I would obviously be happy to chat with you about. Not necessarily in this forum, obviously.
well,
Yeah.
again, I think I am way past that, and I appreciate that. But just like, you know, my dad hearing certain pieces of feedback from the town for years on end, and then us making significant financial and building choices based on those consistent messages from the town, which then have now shifted, which has drastically impacted many things, which again, it is what it is. Change happens. I appreciate that. I'm just trying to understand because and again, partly I'm here on behalf of my parents. So part of it, I'm trying to transfer this information because a lot of these questions would have come from my father. But just for clarification, just for me understanding, also just as a neighbor, and you know, we heard things for a long time, and it sounds like now lots of things have shifted, and now I'm hearing different things, and that's okay. I just wanted to understand if and it sounds like there have been a lot of rule changes. So.
And Danielle, do you have any questions regarding Matt's application?
No, I will say, Matt, just I did put in the chat, like, I don't remember a specific conversation with you and me, or like with you reaching out on behalf of my property with fencing or blocking or anything. Maybe I missed that. Maybe I missed it, but I know you've reached out to my father many times, but again, I own that other side, and the lights and the closeness is now a significant factor. And so again, I just want to honor that if you reached out and I missed that, that's totally fine. But
Yeah.
I just feel like I don't remember that.
Sure. Yeah. I mean, I think we had a lot of conversations, like in-person meetings with you, and Jason, and things like that, and they were discussed in passing there.
But I feel like
Um,
that was about water flow. It wasn't about light or, you know, other things. So again, I just
Sure.
want to note that for the record.
Sure, okay. I mean, yeah, we don't have any, we don't have any written communication about that for sure.
I think that
And
is
again,
also
if
kind of,
the town is I don't want to resist. Like again, if the town rules and all the regs have changed, it is what it is. I'm just trying to understand from that piece of it. That's all. Thank
Yeah,
you.
Danielle, you might want to go in and have a discussion with Tyler about this. That might help you.
we chatted earlier
Oh,
today
you did chat.
about some of the changes, but I'm
Okay.
obviously more than willing to have that conversation
Sure.
with whoever.
Sure.
But this does get to the point of, I think I did raise in my staff notes about the landscaping. It's 5.53B. Again, this is a weird scenario because
It's pretty.
the work is already done, right? And, typically, if somebody were proposing this brand new, there would be landscaping requirements and things like that. So, but you guys do have the ability, if you choose to require additional landscaping if you feel it's appropriate. So
Okay.
that's something to bear in mind.
We can discuss that.
Matt, do you want to just move your laptop back just a
Yeah.
touch?
Any other questions? Is she the only one out there?
Yes, she is, unless.
Do you gentlemen have any questions? No.
No,
Any other questions from the board?
No, I'm gonna just stop sharing if it's okay, guys.
I would entertain a motion.
I move that we take this to deliberative session.
second that.
All in favor?
Aye.
Okay. Matt, we have 45 days to reach a conclusion and give you a decision.
Sounds good.
We will try to be expedient. There's nothing else on the agenda as far as applications. So the next thing is a discussion on changes to the DRB rules and procedures.
Yeah. So hang on
And
one second. Let me get-
Tyler has given us,
Yeah, you can go back over.
Not to
there.
cause
You don't have to-
confusion.
you can come back.
You're officially unrecused as of 7/26, so.
Tyler has provided us with revised rules of procedure and took the time to give us the track, basically the track changes
Yeah.
version.
Do you want me to just
Would
kind
the-
of frame it a little
Would the
bit?
board like to go over it section by section, or would the board like to just hear from Matt on highlights?
Tyler.
Tyler, I'm sorry.
That's all right.
Tyler on highlights.
Oh, forgive me. Hang on one second here. I'm just trying to rejigger all these.
Why don't you hit the high points
Yeah,
to us,
yeah.
Tyler?
So basically what I did was, if I'm just trying to pull up the track changes here. Hang on a second. So these are right here. These are the procedures as they sit today. And obviously there's stuff in here that we don't do, that doesn't necessarily match reality of how meetings have been conducted in the past, kind of predating me and stuff like that. These haven't really been updated since 2013. So I thought it'd be a good time to maybe come back and just kind of bring these more in line with what we actually do. These are the ones, again, this is more of a discussion document. I'm not expecting you guys to accept every change that I've ever made in here word for word. It's meant to give you guys some language to chew over with which that I can further tweak, get some input from the town attorney to make sure we're not running afoul of any state laws that I might not be aware of. This is the track changes here. You'll notice some of the bigger changes. I did swap out. So as of January 1st, we have the new statewide code of ethics that applies. So what I did here in this document, you'll notice I swapped out the town of Richmond regulations for ours.
Tell us what section you're in, Tyler.
It's section 2 policy.
Okay.
So you'll notice that you'll see there's some strikeouts, and I apologize if all the formatting things were screwy. This is kind of the best way I could figure out how to do it. It notes that I swapped out, basically a lot of it, you'll see instead of Town of Richmond statewide uniform code of municipal ethics. Is that what it is? And it's basically highlighting that if there's a conflict between the two, the other should apply. I did some formatting changes. I actually inserted a list here. There's some definitions that are here. Now you have, this is conflict of interest, and I did make some changes to this, and this is again lifting from the statewide municipal code of ethics here. So that definition of conflict of interest is different than what we had in the Richmond conflict of interest, which was essentially mirrored in the original DRB rules and procedures. And it's noted in the definition. So if you actually pull up maybe I can actually do that in case we have any other questions. Hang on a sec. Code of ethics. That's not it. No, that's not the one. Sorry. Divide. Sorry, guys. From 71. Where's the actual final version? Quick summary. There it is. Okay. So if you look at number 5 here, it says conflict of interest means a direct or indirect interest of a municipal official. That's been basically inserted into this document here. So that's essentially what I did here, was to get rid of what we had in our code of conflict of interest, added that in. The big meat and potatoes changes of this kind of come down here. There is some stuff on the minutes. So we had talked about, so what's weird with Vermont is that you don't actually have to vote. You have to have minutes. They have to have at a minimum who's at the meeting, the time the meeting started, motions, and when you adjourn. But other than that, there isn't a ton of stuff that is mandated in there. Some towns do it almost as a transcript. Others do it just the bullet points. I try and strike a little bit of a balance between giving you some flavor of what the conversation is, but it is not a word for word transcript of what we do. But again, all the big stuff's in there. One thing that we should discuss is, again, we've talked in the past about how do we want to approve the minutes? Do we want to approve them? Do you want me to just draft them and they're fine? Do we want to make a point of asking people at the beginning if they have any questions or concerns about the minutes, to want to have them changed? That's kind of your call. I know how we had been doing it is I basically I post them, and if there's a problem, you guys bring it to my attention and we change it. We could work to codify that more, where we just make it kind of like how I added the disclosure of conflicts of interest. We could add in an item where we say, does anybody have any problems with the meeting, with the minutes? We don't have to actually necessarily vote on it. Although if you guys want to vote on them, I don't see any harm in doing that. That's really your guys's call as to whether or not you'd want.
What I recall when we used to vote on them is we would sometimes not have everyone at the meeting the following month for minutes in the past, and we got stacked up with 3 or 4 months of minutes that we never could take care of. So personally, I like the idea of the minutes being posted, and if a member has a problem, or question on minutes, they raise it.
And could you notify us when they're posted? That's the,
Yeah, I can do that. I haven't been doing that, but if you want to codify that, hang on, I'm just jotting down some notes.
Why don't we say that minutes will be, I would suggest that we say that minutes will be supplied prior to the following meeting.
Yeah, and by statute, they have to be. I have them posted by Monday at the latest is when they have to be up. They have to be up within 5 days
oh, do they?
of the hearing
All
date,
right, so
yeah.
we know when they're gonna be.
So they will be posted. What we
So
could
they're
do,
posted basically a week before the meeting.
yeah, absolutely. So the question, or as soon as the meeting's within 5 days of it's calendar days too, not business
5 days of the meeting that we just had.
Yes, so by Monday, the minutes by close of business Monday, the minutes will be posted.
All right.
Now, what you guys could decide is, do you want to just have an acknowledgement that you had the minutes and say, does anybody have any problems? And then if there's a problem, we can discuss it and then you guys can vote on the changes? Or do you want to actually take a vote on it?
No, I'd like to see sort of the more relaxed way that we've been doing it.
Okay. So would you be helpful to you guys to have me codify a little bit that in the agenda or how we do it, we'll just a brief acknowledgement that there are of the minutes and be like, does anybody have any
We could do that.
problems with the minutes? And if
We
there's
could do that.
problems, then you guys can change them and vote on the changes.
I
And then
could make that inquiry at the
Yeah.
beginning, or the chair could make that inquiry
Okay.
at the
and
beginning of each meeting.
Section.
All right, so it's up to us then to look at those minutes.
Yeah, and again, if there's
Without
no
having-
issue, we're operating on the assumption that once I post the minutes, if after the next meeting, nobody gets back to me with
Right.
problems or concerns, that the minutes are approved. If something after the fact, I misspelled somebody's name, so I think the only person I haven't misspelled on here was you and you. I think I've done everybody bad a couple of times. We could always, do you want to vote on the change? Do you want me to just change it and say I made changes, or do you guys want to vote on the change to the minutes?
I think I'd like to just bring it up.
Bring
How's
it
the
up.
board feel about that?
You're talking about bringing it up on the meeting following.
So almost
So if
like
somebody says,
unless-
hey, there's a problem with the minutes, right?
Unless we say something that are approved after the next meeting.
Yeah, and again, if we want to change it, do you guys want to just direct me to change it and I change it, or do you guys want to vote on the approved changes if we have to change it?
I would say-
vote if it's a substantive change.
See, that
Well,
gets a
then we
little
get it- then we
murky
get
for me, like,
Definition of what's a substantive change.
I'm just trying to keep, I'm happy to do that. But I'm also just trying to make sure that we keep it somewhat, not make it too
I mean,
convoluted.
I agree with Patrick. I mean, we're talking about 30 seconds worth of procedure to deal with to make sure it's official. And I think it might be worth doing.
I mean, if only we could do something in 30 seconds, but I agree. We
Mhm.
can, yeah, we
You know,
could, we
if-
could
if you
dispatch,
want
we
something
could
to
dispatch it
change-
quickly, yeah.
We may-
So do we want to do it if it's not like correcting the spelling in somebody's name?
Yes.
Then you guys want to vote on it. Was that,
Yes, I'd
Okay.
agree with that.
Yeah.
Because otherwise, if someone looks at them and something changes and.
Yeah.
After you've looked at it.
so it basically changes other than a technical correction, which is i.e. the name. Let's say if I get the date wrong, because sometimes I do have a template that I use. Sometimes I don't format everything correctly. Sometimes that's which happens. But
Typos.
if we need to fix it, mea culpa on my part, but I think if it's not having to do with the substance or the votes or anything like that, if it's votes or the substance of the meeting, you guys will vote on it before I change it, or I'll change it and say this is what I changed and you guys can approve it. Okay. Again, I'll just scoot on to the next big ticket item. There's a lot of technical corrections and stuff in here. Alternative members, that didn't really change. A lot of it was just formatting here. Public hearings. And again, I think,
So-
yeah, go ahead.
in the order of stuff in public hearings,
Mhm.
H is accept written information presented to the board.
Mhm.
Is that written? I would like that to be written in information presented to the board prior to the meeting. I don't want to encourage written information supplied at the meeting. It's
Mhm.
very difficult for the board to get written information at the meeting and then be able to digest it. Which is why I have tried to be strong about not accepting.
I hear that. I do think though, from a certain extent.
Doesn't always work. I understand
Yeah,
that.
that might be more aspirational. Like I said, I think we can note that there. We could say that it's strongly encouraged.
I worry that saying that almost encourages it more.
Yeah.
But again, I don't know as if we could prohibit somebody from
Because it makes it sound like,
doing it. That's the thing.
I think we either say it all has to be before the meeting or we leave it as is, because I think if we say strongly encouraged. If I were an applicant, I'd be like, oh, all right, I got half of it in, I'll bring the rest of it.
I think that's different. They wouldn't be able to get to you guys without, unless they submit the materials ahead of time.
You're
And
thinking
it's
like the
not-
last
It's
second
not just
email.
it's not just the applicant though, it's
It's anybody.
anybody.
Public.
And that makes it very difficult if 5 abutting landowners give us comments
15
at the
minutes before
meeting. Yeah,
At the meeting.
Well, I mean, Hillview was kind of case in point of this, and that's why we started to do the Friday thing, because I was being, Hillview and Jelena Court did the same thing, is I was getting stuff, an hour before you guys were supposed to meet, and
and
it's
it's
just, I can't,
impossible for us to digest.
I was trying to be flexible, and I kind of got hung out on that one. But that's nobody's fault, they weren't doing anything, nobody did anything wrong, it was just more of a procedural thing on my end, as I was trying to be accommodating to people, and I just ended up not really.
Why is it necessary for us to accept written material at a meeting?
Well,
Someone is here to present material, they can do it verbally.
I get emails though and letters, and like sometimes people want them submitted for the record for you guys to review.
Right.
And I try and honor that request.
But that's before the meeting, it's not at the meeting.
No, but typically I've literally gotten an email, I got an email from her, Danielle provided testimony, but she could have asked me to print you, which I have done, printed emails and given it to you guys that I received hours before the
Well, I
meeting,
know.
so that's, I try and be respectful of the
But
fact that
really,
this
we
is a,
can't beat this.
it is a public meeting, people can
Right,
present
right.
information how they.
No,
want
and
to
in fact,
I don't think there's.
people that want to be an interested party may submit
and
something
written
in
testimony,
writing
yeah.
at the meeting.
I think it's more, in my mind, I'm thinking more of, as an applicant. That bringing stuff to the meeting,
It's bad.
that becomes very difficult.
And I police that, like, they don't get before, if somebody's missing their site plan, if we don't have a site plan, they're not getting on the agenda unless I have
Yeah.
a site plan. Or at
Public
least,
comment.
at least I've seen I might not have the hard copy, but if I've seen the PDF that, hey, this is coming, like, something's hung up down here, I'm willing to be flexible in that regard.
Well, and you guys actually, because we went through this, came up with a really good checklist, you and Keith.
Yeah, I did
For-
it when I first got here, we're retooling them a
Yeah,
little bit and trying to edit them and make them for all the applications.
but especially for the subdivision
Yeah.
stuff, that 3-page checklist is,
Well, it's all stuff that's in there.
yeah,
I
so
mean,
that
it's
kind of,
trying to catch the big ticket items that come through.
I think for public comment, we need to allow it.
I don't think we have a
I
choice.
think we have to allow
yeah.
it.
So you wanna just keep it? Keep that
As
as
is.
is. I mean, there's not
Okay.
much we can do about it. We get down here, site visit. So again, we're not necessarily required to do them. They are if we do a formal site visit, we need a quorum. They're not counted as a meeting. Well, it's weird. You can't take any testimony. You literally just walk around the site to be a formal, to be a formal site visit.
Okay.
It's
Yeah,
a
we always-
public, if you guys
We
go
always
as
get
a
you
group,
for liaison, so-
it's a public meeting. Like, so the public has a right.
I can
to be
remember
there.
one time going as a group in the last
Yeah.
8 years.
Towns got to try and get around it, right, by like not bringing a full quorum. Morrisville, my town did it by bringing out members kind of 2 at a time. So that way there wasn't, well, like the zoning administrator from Morrisville did that. And that you can't really talk, you just walk around the property.
So
So you
that's
guys
what-
literally
That's
see the
what we
property.
used to do, and it was more so that somebody on the board could say,
Yeah.
oh yeah, I saw where that swale is, and
Yeah.
here's what it looks
It was
like.
only one of us that went.
Yeah, that was a
And
liaison.
I think that works well. I like the liaison system.
Yeah, and I do think we do have that here. That's here. We don't really have like a calendar for it yet. Like I said, I'm willing to we did have a little bit of Brown's Court in the last one we had where Brown's Court came up and David's subdivision came up. Like we had a couple people do that, but we should formalize that and maybe just kind of maybe do we want to add procedurally at the end of the meeting, we'll pick who's going to be available for
Well,
a site plan
but
for a
you don't know,
liaison.
you don't know what you need. What we used to do is, I think, is after the kind of the applicants were lined up, then we would be notified and we would
Right.
pick individuals to.
Yeah, here's the three
Here are
hearings.
Does
Who
anyone
wants to
want,
go to
who
which?
wants to go to this one, who wants, and then we would just jump right in.
Yeah.
And fill up the spots. I think that seemed to work fine.
So you wanted to do more ad hoc rather than have a rotation, like, okay,
Yeah.
I mean, I think we
Yeah,
still
and-
kind of
and
had an
Roger.
unofficial rotation.
Yeah, I
But-
think we should just volunteer like we did before.
Yeah. I think it's
I,
a good idea.
I'm good either way. I just think it's important that we do have a liaison.
Yeah.
Someone who's can set eyes on
Well, it
a
was
project.
comfortable because he
Yeah.
would get up at the meeting and he would say, this is what I saw, and if there was a question, he could say, oh yeah, that's not over there, it's over there, and I mean, I thought it was very valuable.
I agree.
and again, it is just one person's opinion of what was there, you know what I mean? It's not.
It really isn't an opinion, it's an observation.
True.
And
Do you want me to make that in the terms of the order? Do you want me to kind of make that the liaison thing is your preferred method? Because we still have we have the ability to do this, and a formal site visit. And if
They're
we do
ve-
do a formal site
They're
visit.
very difficult. When you have a whole board or a
Yeah.
good part of the board there, avoiding questions and ex parte discussion is impossible.
Well, do you want me to move this instead of from F to A? It's like, this is our preferred way of doing it. We still, I think, should
You can
keep,
leave it as F.
you want to keep it as F?
When I know in the past when we did these, at least I always made a point to tell, if I was there with somebody on site, I would always say, you can't give me testimony.
Right.
I can only ask you questions that are like topical, like, is that your fence? Or
Yep.
where's the property line?
Yeah,
Or,
right, exactly.
it's not a public, it's an observational thing, so.
We also used to make those along with the zoning administrators, I remember.
Yeah, and I would anticipate probably, I don't mind. I think the one that I did with David, I was there. That was like when I first started.
When we
Yeah,
walk,
it was usually the ZA.
when we walk through all that wetland.
Yes. That was the very first one. That wasn't too long after I started, actually.
Heinsberg one,
Yes.
the road in Richmond,
I
the
just
driveway in
remember-
Richmond.
Well, do you guys want to tweak this? Because it notes like the standards for site visits, like, so do we want to note that the preferred option is to do a project liaison, but in the event we do a formal site visit, we follow the rest of the procedures?
The site
think
visit
that's
the way
good.
it is, and we can just say, that we have the option to do a liaison visit.
Okay, so keep it, you don't want to make any changes
I don't think
to the
so.
order or anything else here, okay. Yep. List of participants, use of email, that's mandated by state statute. Did I make any changes?
Yeah, because I think it's good, because it says liaison, it can be a liaison, or if prior to the hearing, the DRB chair determines that the full DRB
Yeah, that's good,
is
I agree.
necessary. I think,
Yeah, that's all procedural. So conflict of interest, this is a kind of a big meat and potatoes one. So these changes, we pretty much mirrored what we had
can I make
in,
one?
Yeah.
This is the second section 11 in a row.
yeah, see, there we go. And this was the fun part, was that these weren't done in a list format. Somebody manually typed out the list. So that's why you have so many corrections, because I actually had to go back in and install a list. So,
Just wanted to,
yeah, oh,
Or
I
I
can't
forgot.
edit this. Hang on one second.
So this document you had in the archives that you
Oh,
are
it
editing,
took me a minute to hunt this one down. Hang on one second here. I just want to know. Cause I'm not editing it right now, so I'm gonna go back and do it and double check. List numbers.
If either of you gentlemen have any input, that'd be fine.
Yeah, maybe comments. Is that good
Sure.
time now or?
Pardon?
Is there more you want to go through first before I give some
Are
comments?
you? Yeah,
I mean,
let's-
we're gonna
let's
get
go
into
through
the
list.
conflict of interest stuff here, which might probably bear a lot of what you're.
You should keep going if you want, but I'll wait.
Okay, I was just gonna suggest if you'd prefer to go now, it makes no difference
Yeah, I
to
don't-
me or to us, or, okay.
Doesn't matter to me. So there's something that's best for you.
So I'll just kind of keep going. So this notes, I kind of just noted the sections here. Made some changes here and again. This is again, trying to make this more in line with what's in state statute. Now, one thing I did add, which we don't necessarily have to do and was somewhat more of a thought experiment on my end, is like, if you guys have or somebody on the board feels another member of the board has a conflict and should be recused at the meeting, and that person doesn't feel that they have a conflict, what do we do? So this
What the
is,
US Supreme Court does,
yeah, so what I kind of
avoid
did,
it.
well, because kind of what I did is with that in mind, is I kind of played with that idea and tried to flesh out a process by which you guys would go about considering that in a way that, you know, took that complaint seriously, but was also set up, I think, a fairly high bar in terms of like, it's got to be a pretty obvious blatant conflict, like, hey, you know, somebody handed somebody a bag of money in the parking lot for them to vote this way, and I have the picture of it right here, kind of thing. Right?
you're
Something,
saying
something
because-
pretty blatant.
Because technically you cannot force somebody, even with a vote. to
See, I
recuse
don't,
themselves.
and this is why I want to get the attorney's input on this. This is my brainchild. Mostly to see if you guys are interested in it, and if you are, I would want to run it by the town attorney to make sure that that legally we can even do that.
I think,
That's what my thought is, if it's like four of us on the board are like, you have a conflict and that person doesn't want to recuse themselves. Can the four of us say, well, too bad?
yeah, I also think it's a good idea, especially given the last time, if there was a recommendation from other people on the board, then it's more likely to be like, oh, okay, other people think this is a conflict of interest,
Yeah.
but we never even had that really part
Well,
of it in
because
there.
that's what I did here. So basically, so once a request, and this is kind of takes you into, it's really B. I'm sorry, it's difficult to read in the track document. Let me see if I can't. Is this the right draft? It's a little cleaner to look at on this one.
Just tell me what section you're in so I can see it on my
Yeah, hang
screen,
on
because
one
I can't
second.
possibly read that.
No, it's okay.
11.
Hang on one second.
Talking about 11B.
It's technically 12, but 11B. yeah.
11-2
Yeah.
B.
So this kind of, it starts in E. It says, a board member shall recuse himself from any other matter in which he or she has a conflict of interest. The board member with the conflict shall disclose the conflict, explain why they need to recuse themselves, and then remove themselves from the board and sit in the area reserved for the public or whoever's applying, right? Matt did that.
I get it.
This is if the applicant or any person may request that a member recuse him or herself due to conflict of interest. So this is like John Smith comes in and says, you know, Matt Dyer, you have a conflict with the board, or this is your cousin, or, you know, you're gonna build the house or something. I know you're gonna build the house or whatever it is.
Mrs. Thomas, you have a conflict.
Exactly, something to that effect, if you want to make it.
All the
federal.
time.
If you want to make it federal, right? And then says, okay, how do we deal with that, right?
Why can't we just have a majority vote?
Well, this spells that out in a little bit more
Yeah,
of
the
a,
next sentence says, it
process.
shall not constitute a requirement.
yeah,
Sorry, I'm jumping.
no, that's fine. And again, I may have forgot to scrub some of that, so that might be a drafting error on my part, but basically the intent was okay, somebody makes that. The board can deliberate on that, says, do you guys, and you can either do that in public. I think it should be in public, because I don't know as if we can do executive
Okay.
sessions.
Well, I think it's good that we allow this deliberative session if necessary, but.
Yeah.
Because
So basically what it would be is the person who's been accused, for lack of a better word, right? Can't vote on it.
Yeah.
and everybody else votes on it. And the way I was trying to do it to set a high bar, as it's not a majority, it's everybody else present has to agree. Like, it's gotta be something that's like, again, Matt got a bag of money in the parking lot kind of deal. At least that was my thought process on it. You don't have to do that. This is, again, a thought experiment. It's a brainchild. It's meant to have a conversation.
Understood. I guess. You know, to Matt's point, and this language struck me earlier. Like, I don't know why we're getting to accuses, like, as if someone has done something wrong. I think, you know, regulations ideally are black and white, and, you know, there are situations that invariably will be gray, and I think a reasonable, honest person may just not see that they have or believe that they have a conflict of interest. And I think the board members should be able to say, hey, you know, are you sure about that? Or so, like, if the member of the public is doing it, they can request that someone recuse. So I guess I would suggest that we follow something similar. So we don't have to accuse one another, because that sets a really high fraught bar. And just basically, you know, question or request. I mean, it's semantics, but I think accused is heavy handed.
So you want, instead of getting accused, if a member of the board though, so, but I guess when I said accused, meaning it would be like if one of you guys, and you, not saying you guys would do it, but let's, you know, this, you guys won't all be here forever, right? So say there's other members of the board and they feel very strongly that a certain member or whoever has a conflict, and that member, for, I think, well-intentioned, feels that they don't, how do you want to adjudicate
I think
that?
the
Or
same
should you
way.
adjudicate?
Maybe
Maybe
point
it's
is like,
just
it's
the
just a
word
request. You know,
Yeah, maybe if
Matt can say, I request Patrick be recused because, you know, I believe he has a conflict of interest.
And
Maybe
Patrick
it's-
says, well, I don't agree, and then.
Then we go to
Then
vote.
we have to go to a vote, and I
Maybe-
think the vote should be majority, but
I agree.
why should that standard be any different than someone
I think it
from
should
the
be the
public?
same.
I think it should be the same.
Agreed.
Yeah, maybe instead of accused, it's perceived.
A much better word.
I don't know.
Or just request that they be,
Request.
well, you gotta have a reason for
If
the
multiple
request. And the
members are perceived to have.
Well, somebody makes a request, I mean, and again, there's some language in here to prevent like duplicatives. Like you have 10 people and they all make the same request, like you guys do it once. I think I noted in here that the chair has the ability to be like, we talked about it, you know what I mean? We're done, we're moving on.
But the point is that I think that the standard should be the same for anybody to request a recusal, and I think that the vote should be a majority vote and not a unanimous vote.
I agree, like you could add that to B, the applicant or any person or board member may request that a member be recuse himself. I mean,
Exactly, I think
I
that's
don't
good.
think it needs to be a different block.
So I'm hearing you were interested in majority vote instead of unanimous.
Yes.
Yeah.
Yeah, I mean, unanimous is difficult. so-
Well, but that was my point, is I wanted it to be a high, I thought in my process to be a high bar, also to prevent it from being abused to a
Majority
certain
on a
extent.
on a small board like that's.
It's pretty much gonna be
high bar.
unanimous anyways, like in an instance, unless all you guys are here.
I think we should try it as a majority. I think that's a.
Well, because my problem would be is that, okay, let's say if there's only 3 of you here. One member accuses the other member, because I note on here that if 2 members do it, both of those members can't participate.
Why?
Because they both have conflicts.
Well, wait a minute, if one person requests a recusal of another one,
Hmm.
One board member, why shouldn't the board member that requested be allowed to vote?
Because I feel that would be a conflict potentially, like, and I said, it's trying to make it like you guys decide. You disagree. Again, this is just a thought experiment.
that-
You don't have to do that.
Because then, like, if somebody happens to realize something,
I think that's,
them not being able to participate and vote in the hearing is a deterrent from calling out that person.
Well, I think part of my point was I didn't want it to be like frivolous, you know what I mean, or personal, meaning that,
but if it's personal, then the other board members will have to ferret that out when they make their decision as to vote the guy in or out. I don't think that the guy who makes the request should be prevented from voting. That doesn't make any
Okay.
sense.
No,
Yeah, it's not like some sort of,
you know,
someone's done something horrible and this is going to
yeah, even
HR department or whatever, or litigated. I mean, it's just, yeah, we should be able to hey, I request that so-and-so be removed, and then we have a conversation, and maybe, we learn from each other.
Yeah,
I might vote that I do be recused.
I also think it would be good to add in here giving somebody a recommendation ahead of time before you have to.
Well, sometimes you don't know the.
There is some of that with the new code of ethics, like if you feel that you have a conflict of interest. Or that, but you still think you could participate,
Well, right, well,
to submit that in writing ahead of time, that's a new thing.
okay, so
So we're
that's
gonna have to
right.
play with that. I'm sure we'll mess it up the first few times that we try and do it, but we're.
Because honestly, most of this is trying to keep honest people honest, right?
Yeah.
And
Again, it's the bags of money is really what we're
That's-
trying to.
so,
Right here, like,
It's just.
No, I don't think so.
You don't think so?
I think it's
I think that's
more,
corruption. That's a crime. This is just conflicts of interest.
Yeah, fair enough.
right.
We're beating this to death. I think we gotta.
So again, so what I'm hearing is then for this, you would like to change. Accused for somebody making a request. A majority vote, not unanimous for if there is that person has a conflict.
Right.
And then the person who if a board member accuses another board member, the board member who accuses can vote, but not the person
The person who is
accused can't.
the accused, if you want to call it that, doesn't get the vote.
Okay. And again, I don't know if this is necessarily legal, but in my mind, I think it's a better way of dealing with. If somebody brings it up at the meeting, you have a substantive way of dealing with it ahead of time before you get into the roads of making decisions and then people are,
I mean,
feeling
really
it
what we're
based
talking
on
about
that.
is what
I don't
comes
expect
down
it to
is
happen often.
Somebody is gonna recuse themselves, and if somebody isn't gonna, but somebody else feels they should, a majority votes
Right.
to decide whether that person should or not, is really what we're
It's
talking
not
about.
that hard.
do you want to have the other person the ability to vote too? Is that cleaner? That just let's say somebody makes a request and then
the
everybody.
person
votes?
that's being accused, right?
No.
No.
Okay. So that was the big one of the big
In other
changes that I had
words,
there.
So Tyler, on this note, but not related to this specific document, you said we're supposed to send in a,
So
letter now?
new, and again, I'm still trying to, this is gonna be a little bit of fly the plane and build it, kind of a little bit, because this is brand new. Technically, if people make requests for you to disclose a conflict of interest, right? If it comes up at a meeting, you can still participate in the meeting, provided that you say that you don't have a conflict of interest. However, you are required within 5 days to submit in writing to the town your reasons for,
In the town.
to me, I have to record, somebody's gonna have to record it, so.
So
more than
after the
likely-
meeting, you write.
Within
"Here's why
5
I
days."
Recuse myself.
Yeah, you didn't recuse myself, somebody raised a conflict of interest. I didn't recuse myself, here are my reasons why I felt I didn't need to recuse myself and participate. We should bring that up in the meeting
I
as
think that's
well.
fair.
Also,
What
if
do you do with
somebody,
this?
I have to keep it on record.
You don't. So there's no decision made,
I keep it on
you just
record.
keep it on.
Here's the problem with the statewide code of ethics is I really liked ours better. I thought it was more detailed. There's no enforcement mechanism in here.
Let's tip.
So it's kind of like, if we don't do it, I don't know what the recourse is. I mean, yeah, the board could,
But what
you
would
could
it
get
be?
kicked off the board in theory if the select board wanted to remove you guys. Again, I don't know how that
Wage
process would
garnishment
play
from
itself
our-
out necessarily.
I mean, there's problems, right? Obviously, you don't want decisions based on,
No, but again, I get what they were trying to do. I mean, this is the problem with having a one size fits all policy is it's hard. I mean, this is only 5 pages either. Too, you know what I mean? Ours was 9. Ours could have been more. I'm personally of the opinion of, I would like a larger document with stuff more defined. Like to try and avoid gray terms personally. That's how I like it, but.
Tyler, can I make a quick comment on something you just said?
Sure.
My interpretation of something you said is different. I don't think if someone just accuses somebody of conflict of interest, you have to file that paperwork. It's, if someone says, I have a conflict of interest, but I feel I can proceed anyways,
Gotcha.
that's what I believe.
Otherwise,
Yeah.
it could just be anytime.
Well,
somebody-
that was my problem, because when I read it, it said,
Could be wrong, but
So it's like,
that's not
like.
It said something.
It's a
That
self,
makes much more
If I
sense.
just say, oh, I think you have a conflict, but my statement's totally, there's no basis for that.
right,
And
so
you
it's
like,
only if you announce it.
you say, oh,
Yeah,
I
let
do
me
have a
see
conflict,
here.
but I can't.
It
proceed
was
anyway,
conflicts of
then
interest.
That's when that's filed.
That makes sense. Yeah.
If I
because
mean,
otherwise-
it says, and like, this is in B, and I would encourage everybody to read it in some recusal. If a municipal officer is confronted with a conflict of interest or the appearance of one, the officer shall immediately recuse themselves from the matter, except as otherwise provided in two notes that A, notwithstanding subdivision one of the subsection, B, any officer may continue to act in a matter involving the officer's conflict of interest or appearance of a conflict of interest if the officer first lists all the things, and then you have to submit written non-recusal statement to the legislative body, so it would actually go to the select board.
Yeah, but
of
we
the
can throw it
municipality.
out before that, if we want to.
Well, that's what I'm saying, I don't, assuming what I propose is legal and you guys can do that, which we have to figure out.
100%.
But that's what I'm saying. So it's real or perceived. So if John Smith comes in here and says Matt has a conflict of interest
Right?
based on whatever,
Is
you
it,
have to address
I
it.
mean, the problem is you could have personality problems between neighbors. And they could have it out for a board member. And
Or
come in
vice
and go-
versa, right? It's,
Or,
yeah,
well, but I'm talking about
Mhm.
if someone has a problem with one of us.
Yeah.
And they constantly are accusing them of a conflict.
my issue is the new word is appearance, right? Appearance of,
yeah.
that is so broad and so,
But it is the law. I mean, that's.
no,
what-
I know, I'm
what
just,
it
I'm
is.
just saying, like, I think that's very,
That's my problem that I have with it, is that it's
Appearance to.
really, boy,
Here's
it's
the
wide open.
variety. I mean, we have that all the time with.
Here's what I also would say. I've
Yeah.
been on this board for 10 years and I can think of one situation where a board member probably should have recused themselves and they didn't. I don't know if you guys remember this, but.
Yeah, and again, I don't think it's gonna be common, but I do think it pretty clearly, I think, says to me, if the officer is confronted with a conflict of interest or the appearance of one, you have to address it. And if
When
you feel
say-
like you can
when say
participate,
Address it.
it says it right here, it's in this section.
You can't just say, great,
You have to say, like,
I don't
I
care.
feel I don't have a
Right.
conflict
But
of
when you
interest
say
based on X,
address
Y, or
it,
Z.
let me just, yes, make sure that I'm understanding it. So someone comes in from the street and they said, Matt got a conflict of interest in this case. Matt said, what? I don't have a conflict of interest. And the guy says, yeah, you do because. And so the chairman says, okay, let's vote on that. What is that?
That's what I'm trying to put in place, but I don't know if that's exactly
It addresses
legal.
it.
Yeah,
I mean, that's a word.
because I think the
Like,
member
Different
has,
song.
I think the
That's
member
my
does have
problem.
rights to choose to, if they legitimately feel they don't have a conflict of interest and want to participate.
But then you have the
Hmm.
dialogue between the person who says that he does and the person who's being accused of having a conflict of interest, which the board can observe and then decide,
Yeah.
which side they want to be on.
I-
There's absolutely nothing wrong with that. in
No, I
my
think
view.
that works.
I mean,
wait,
then.
it doesn't have to be vote on it right now. If there can be a discussion.
Well, I
It
think
can be
you have,
discussed.
yeah,
Yeah,
but you have to, you have to deliberate.
But the point is that addresses it and it covers somebody who it covers that word appearance of, it's for us to decide whether the appearance of is relevant or not.
Yeah. It doesn't absolve that person though, even if you guys find that there isn't one, that person has to supply the reasons why they
Even if
participated.
somebody comes in
No, but-
here and accuses somebody of having a conflict of interest. And just because we have to decide that the guy that came in here and accused him of it is coming off the wall somewhere. And we say, okay, you're full of shit. We're not gonna even think about that. We're gonna say that he doesn't have a conflict of interest and all we've done is created a paperwork giant dilemma.
You
for
don't
this
have a
guy.
choice. You have to do it.
No, but I think, didn't we just say though, that if somebody else calls you out, you don't have, and you stay on, you don't have to write in 5 days.
If somebody else, so you do, I think if somebody accuses you of doing it, and this is like my issue with B is like, if somebody accuses you of doing it, you have to say why, acknowledge it, say why you don't have a conflict of interest and why you could participate. You can participate in that meeting, but 5 days after, you got to submit in writing to the select board
Within 5 days.
within 5 days of the meeting.
But
Do the select board have any power?
Yeah, so what if you don't?
Again, this is like the enforcement bit of this is it's ambiguous. And again, this is the problems of
I don't
having a
like that.
5-page
I
document.
don't like that because that means at every meeting, somebody could come in.
Yep, that's my concern with it.
I like what Bradley's point was, which I agree with, that if you self-announce that, hey, I know this person and blah, 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 but I don't think I have a conflict of interest, and here's why, so I'm gonna sit on the meeting, and then you present in writing within 5 days. But if somebody else comes in every single time this happens, I mean, I get it, we're not talking about a huge deal here, but like, it becomes.
Well, it could be, and this is my concern with it when I read it the first time. In writing this, because I wanted to, take the language, make sure there's some continuity in like terms and how things are defined. When I read it, this is one jumped out at me is if a municipal officer is confronted with a conflict of interest or the appearance of the officer shall immediately recuse themselves from the matter except as otherwise provided in subdivision 2, which lists the process there. You don't have a choice. You have to address it right then. And you have to decide, are you going to recuse yourself? If you're not, you're going to have to you're going to have to list the reasons why you're not recusing yourself. And then you have to submit in writing within 5 days of doing that. If you don't do it, technically that's an ethics violation.
That's not my interpretation of what
What's
that is.
your-
Where
tell
is that?
us
I
yours
agree.
again, Bradley.
I'm sorry.
Tell us your interpretation.
So there's a difference between an accusation, a real conflict of interest and a perceived conflict of interest. Those are 3 different things. An accusation does not necessarily mean that there's a real or perceived conflict of
Right.
interest. If I say you have a conflict of interest because you were hanging out with Martians that Right. Okay, clearly that's an accusation there's no basis whatsoever.
Right.
You can confidently sit there and say, I don't have a perceived conflict of interest. I don't have a real conflict of interest. I'm confident in that. I'm gonna move forward. I don't need to file this paperwork.
Right.
Right, so it's it comes down to, is it a real or perceived conflict of interest? An accusation does not make it necessarily a perceived conflict of interest.
But who's gonna make that distinction?
Ultimately, you have your personal responsibility to decide for yourself if you have a conflict. That's the first step. But beyond that is if there's accountability to, if the select board decides, if someone files a ethics complaint and says they disagree, then you have to be willing, confident in backing that up,
Okay.
right?
Well,
In the example I gave, it's easy, obviously,
That
you
certainly
associate with
makes
Martians.
sense.
So
clearly
is,
there.
is that why you have to file this written statement to offset the claim by the third
No.
person?
My understanding of the statement is if it's a real or perceived conflict, you're saying why I can proceed anyways. Even though it's a real or perceived conflict, I have reason to believe that I can still proceed fairly. And I'm documenting that why I believe that.
Yeah.
So that's the difference between an
Well,
accusation.
and I like how you frame it. Unfortunately, again, I think it's as I read the language, I don't think that's what the language says.
Well,
Because if you're in one, it says first off, if you read, this is the section that it references here, you read A, duty to avoid conflicts. The appearance of a conflict shall be determined from the perspective of a reasonable individual. So
Yeah.
Martians, the Martians
It's not a
told me that
reasonable
you're doing that,
accusation.
right?
So,
But again, that's still a pretty broad, a reasonable individual, right? That's a pretty
Yeah, but-
broad,
with knowledge of the
Abrupt.
relevant facts is the.
well, what
the
is
key to
that?
this.
But what is,
That means knowledge of the relevant facts. What are the facts that create the conflict?
but they may feel that it is, that they are presenting relevant facts. You guys might not perceive it that way,
Yeah,
right?
but at some point, the buck has to stop somewhere, and it's gonna be someone on the board that says there are no Martians interfering with
Right.
Patrick, so I'm making that determination. If the select board has a problem with that, with me saying that, then we'll cross that bridge, but at the end, you can just keep spinning and spinning and spinning.
Well, that's my problem with this language is it's vague. It's vague language. Like, again, I prefer
So-
things to be much more defined, but I can't tweak this.
So Bradley says,
I think it-
Bradley is bringing up that if someone files an ethics complaint, but if someone accuses a board member of a conflict and the board member says no and writes that statement that goes to the select board,
Then we're good.
what do they do with it?
Right.
It's not an
File it.
ethics complaint,
You
right?
you file it.
At that point, but it's not an ethics.
Yeah, I mean, they'd have to figure it out, but this is, again, this takes me to my concern with one is that if a
Doesn't make
municipal officer is
doesn't make
confronted
sense.
with a conflict of interest or the appearance of one, the officer shall immediately recuse themselves from the matter, except as otherwise provided in subsection A, and then it goes on from there.
I think the reasonable individual part is a key part to this, because
The philosophy major
Marcia
is like
Zuckerberg.
cringes at that.
because
It's very vague.
conflict of interest or appearance of one, a reasonable person can determine what that
So,
is.
so let me tell you
I
how
think-
much time we spent in law school discussing what the reasonable man is.
You know, yeah.
But technically,
And the appearance of impropriety.
Well, that's the problem, like, you know, it's like that arbitrary and capricious or whatever those terms are, those vaguely specific
Capricious.
terms, specifically vague terms. It's like,
Well,
that's what gets me there. And yeah, logically, most people think, oh, it's a reasonable person, right? But if you get 5 people in a room, well, what makes somebody reasonable? You're
this is
gonna
why-
get 6
this is-
different
this
opinions
is
on
why-
it.
This is why you have lawyers.
here's my problem.
can't you get through
generally is sometimes it's okay for, I just think the more you try to define it, it's gonna make it more complicated
I think you're right.
as opposed to
Right.
leaving it simple and saying, if somebody has a perceived, egg up there.
If we're stuck with this, then we'll deal with it when it happens.
Right.
I don't think that.
I agree.
That's-
I think it's
Because we
not worth
really
worrying
can't,
about.
we can't predict how we're gonna react to this.
And we can't predict every possible
No,
scenario.
and we-
either.
No, and I
We
don't
know
expect
that.
you to.
I mean, there's always gray areas.
Again, this is my little bit of my personal bias in that obviously, you know, you're never going to be able to define away everything and have something be functional. There's always going to be judgment calls.
Well,
But I think, you know, rather than have a 5-page document, I'd rather have a 25-page
well,
document. It's more
the
fleshed out.
zoning administrator, just like to
Disagree.
have everything spelled out, but.
Well, it's philosophy too. I like the defining terms is a very big part of
That's
philosophy.
what the 2+2 rule is. If you ask a philosopher, it's whatever, it's approximately 4.
No, that'd be a priori truth. It's true because it
If
is.
you ask
So,
an
Bradley,
accountant,
did
it's
you have
exactly
more than
4,
you
but if
have
you
to
ask a
say?
lawyer, it's whatever you want the answer to be.
Can I just say one last thing?
Mm.
The whole point of conflict of interest to me is vague and up for interpretation.
Mm.
So I don't know how we're gonna get past that
Yeah.
by writing more and more.
I think you can narrow the funnel, but I totally get
You know
your
what I mean?
point. You know, I get it. And again, this is just my mental personal bias about how I would deal with these things. Obviously, other people have their own thoughts on that matter, and it's neither right or wrong. It's just how you want to proceed.
Bradley, you ready to roll?
I've just got quick comments, so it won't take a lot of time.
Thank you for putting us out of our misery.
So, yeah, I think, has anybody here taken the, curiosity, there's like a 45-minute online training for the ethics. I think if you take that training, if you haven't already, some of the kind of debates and conversations you're having will be cleared up a little bit. I
Hope
think
it's more interesting than the notary public training.
I don't know, I haven't taken that one, so I don't know. I tend to agree that like simplifying what you have, like don't keep it within the municipal code of ethics, it probably makes more sense, like don't make it more convoluted than it needs to be. I think stopping and thinking and having a moment to say like, okay, let's reflect, let's have a conversation. I think those are all good things to have in your rules and procedures, but I tend to think like, don't overcomplicate it, right? So a couple of quick comments. So there's a few definitions and assertions about what is and is not a conflict of interest. I think that's problematic because this document can't unilaterally decide that, right? There is a like a municipal code of ethics that prevails over this, so you might want to take a look at some of that language. And just make sure, like, you could use the Ethics Commission as a resource too, to make sure that anything you have written here isn't in conflict with what they have, for the new.
I'm gonna run it by.
Yeah.
attorney, change it anyway.
So some stuff in there about ex parte communication. The document also seems to conflate conflicts of interest with ex parte communication, like that there's like the ex parte is a conflict of interest, those are two different things. So I think that's problematic to try to define ex parte as a conflict of interest. I think that I would probably simplify that. This certainly can be related, but they're not the same thing. And then as far as site visits, I agree that DRB members should definitely avoid ex parte communication during a non-public site visit, but I don't see how that can be avoided altogether. There's going to be ex parte communication just as a result if it's not a warned meeting that the public's at. So at a minimum, I would suggest that DRB members should be required to disclose any ex parte communication that occurs during a non-public site visit. Just say, oh, this is the nature of what we talked about, et cetera, right?
I
Just to
agree
get that
with
on the
that.
record. Doesn't.
And I think not disclosing it, that's the conflict, not the ex parte itself. is
I
the
wouldn't call it a conflict, but no, that's the problem.
Conflict of
Yeah,
interest.
yeah. I think if you disclose, like, you have this conversation, that goes a long way, right? So, regards to open meeting law, so, you do need to allow general public comment under Vermont's open meeting law. You can certainly limit public comment in your quasi judicial hearings. That's a different matter altogether, but not while you're in the open meeting. And you can set rules. You can say like, oh, it has to be at the beginning of the meeting, or like when, or the lengths of the comments, that sort of thing, for sure.
Sorry, but is that discretionary or is that required?
So
The
open
the
meeting-
general public comment. I was
You
scrolling
have to
through
have,
this.
you have to allow comments. You could say,
But we could limit duplicity.
you can,
I think if it's a quasi judicial proceeding, you
Yes.
don't have to allow general public comments on non-agenda items. So
Yes.
like,
Yep.
I don't like how you did this, right? You have to give the board, members of the public, the ability to weigh in on an agenda item, whether it's Matt's application. or
But I think
whoever's. Once we're in this, like other, then yeah, absolutely.
I also think though, that we don't have to sit there and listen to 10 neighbors say the same thing.
No, you do have some discretion.
yeah, I'm trying to make a distinction
Yeah,
though
separate.
between a public meeting, like before and after your quasi judicial hearing, right? Like in your quasi judicial hearing, that's a different matter because you can very much limit and control how the public engages. That's your discretion. But in an open meeting like we're in now, or before you go into your first hearing, like you do need to have some process for public comment, right? And then you can limit it, you could say it as this 3
You
minute
mean
time
just like
limit.
the public comment you're making.
Yeah, exactly. Yeah, that's all. Yeah. And you can say it has to happen at the beginning. You can say it has to happen each agenda item. You can decide where you want to hear that comment and put rules on it, but you have to have some.
So are you saying, you're saying that we should do this as a general rule, every time we have a meeting, say, before we begin, does anybody have any public comment? Or after we
That's
get
one
done?
option. Yeah.
I,
I don't
The
think. you
select
have to
board
get
cha-
quasi
the
judicial.
select board tried that and
Yeah.
it brought in some craziness. And I would rather see comments with each application.
Oh, sure. You can say that you want the comments with.
Yeah.
Yeah. I'm just saying, like, if someone has something to say that has nothing to do with anything on the agenda and they have something that they want to say, technically they have a right to come in and say that, right? But I don't, you can set boundaries on that and structure. I'm just saying there has to be some component of that.
Bradley, you say technically they have the right to do that. What document gives them the right to?
So
do
this
that?
is Vermont's open meeting law.
Okay, that does tell them
Yeah.
that they have the right to do that.
You have a right, you have to accept public comments at a meeting. I
But
did look at the
public
specific.
comment that is not related to an application.
So this board is a special case because you have quasi judicial authority. So in a quasi judicial, when you're in that quasi judicial hearing, that's a whole a different set of rules.
Okay,
You don't
but-
have to accept comments in the same way in those.
But we still do have to accept comments even though we are quasi.
Because you're not always doing quasi judicial matters. You're still a public board when you're not in those quasi judicial hearings.
Gotcha.
So,
So like theoretically, at the end of a meeting,
yeah,
Like
the
if we're
whole-
doing, if
the
we're
whole
doing that, if
evening.
we're doing this, like other
Right.
business stuff.
exactly. Yeah. If you have other business.
What
But
if we don't?
Yeah.
What if we don't
Technically,
have other business?
you're technically still, when you open your meeting, but before you open the hearing, you're technically in a public meeting at that point.
right, or like when we close.
Yeah.
Close the
Yeah, I get it.
specific application before we adjourn.
Yeah, I'm not entirely, because I've read that section too, and I don't know it verbatim. But I think it's for quasi judicial, because I looked at that when we were talking about. Because I think the first time we talked about, it, did you want to provide a general public comment on non-agenda items? And I think we advise again, because we don't think we're required to do that. Obviously, for every agenda item, we have to allow the public to comment on it. That's why this other business, like,
Well, that's,
About
this
that,
is more
we can
administrative, like I
control
said.
that.
Honestly, I'm.
I could look more into it.
Solely
I
for
could be wrong.
myself,
I could be wrong.
I'm totally, I don't have I mean, obviously we have to anyway, but like, I don't see it being a big problem.
It's
like-
not a big problem if you can control the time.
yeah, you
Of
can put a
course,
time limit on
but
it.
I
Yeah.
think,
Yeah.
You'll be here all night.
well, that's what I was gonna say is I don't know that we will because there's so,
You put it at the end of the meeting?
how many times
Put
does
it
that
in.
happen?
Well, that's why I mentioned it, but again, I just don't. from when I read the statute, and
see the
again,
statute.
I could be wrong, and we
We're-
could,
we're- we-
I could put it on the agenda for another meeting, like, look at that and see, do we need to require a general public comment
I
or
want to
not?
read the statute.
Yeah.
You know,
it's a
per
Vermont
per
open meeting
state
law. Yep,
statute, I
Yep.
could do that. I mean, hang on a second.
Yep.
I mean,
I don't know if you want to read it now. I mean,
it's hard for me to believe, I would imagine most people who are looking to make general public comments are
Yeah.
going to the select
Yeah,
board
yeah.
anyway.
Yeah, that's where they usually.
But there
go,
might be
is
things, like,
select-
for example, like someone wants to change, they say, oh, there's something wrong in the meeting minutes, I'd like to correct that,
Yeah.
right? That's a thing someone might want to just come
Right.
and tell you about, and they need to have the opportunity to do that. That's just one example I can think of where the general public would need that opportunity, so. Again, you can limit it if you find it to be a problem, you can certainly put a time limit on it.
Right,
You know,
like
that's-
15 minutes for that or.
Well,
3 minutes per
somebody
person
comes
or
and
whatever.
Yeah.
they try to reconstitute something that a decision that we've made before. They come and they say, well, you guys made the decision last week and I don't agree with it, and this is the reason why, or you screwed up, or this guy, I mean.
Well, I think we have to be able to hear that.
Yeah.
You can say thank you for your comments and.
Exactly.
That's.
Well,
yeah,
and I
yeah.
can also look up and I jotted it down for the next meetings. If it's something that you got, because I mentioned it before. I took it out. I had it in original, like the very first redraft you saw of this. I took it out because you guys weren't super interested in it. I could always put it back in, and I can also pull up the open meeting law for you guys to look at and see, are we actually required to do it? And that answers if we're required, then obviously we have to do it. But if we're not, but you guys at your discretion do want to make that an option, I don't think it's a bad thing. So you could figure that out, because we want to make sure is if we are required, right? It is a hard call out for it, then we need to make sure that we're complying with what we need to comply with. But if not, and you guys at your discretion want to allow that, I don't think that's a bad thing. It's really your guys' call how you want to run your meeting.
Quick thing, you touched on this a little bit earlier too, the idea of going into deliberative session to talk about if someone has a conflict of interest. That's definitely not okay under open meeting law. You can't do deliberative or executive session for that reason. That's
Specifically for conflict of interest. discussions.
well, you could potentially do executive session, but my interpretation of the executive session spells out, definitely, you can't definitely do deliberative. That's not a deliberative matter. You could argue executive session, but you'd have to come up with a specific things that fit that, and I don't see how that fits, right? Like, you'd have to look at that law and see like why specifically we're going to executive session, and I can't imagine and how you would describe that in a way that.
Well, we have
fits
it
that.
here,
Well,
deliberate.
and to be fair, I didn't say, and I think it might have been poor wording on my choice, is that it wasn't a formal deliberative session, as in like deciding an application, is that they have to deliberate
Yeah, but
in
you-
public about how they.
There is something in here though that says,
Deliberative session?
It does, yeah.
Okay,
Yeah.
again, I
Yeah.
drafted it a while ago. I very well may have done that. That's why,
Yeah,
again,
if it's
I'm
a
not
public
100%.
conversation,
Well,
sure.
yeah.
You've always had the right to, in the middle of an application,
You can go and
go
deliberate.
into
to
deliberative
decide something.
session on a certain point of some sort.
I think
We've never
he's
done
talking-
it that I can think of, but.
I think he's
we have it
talking
right.
literally just specifically about the conflict of interest.
Oh,
thing.
Yeah,
okay.
yeah.
And I don't know, to your point, it very well may be like
Becomes a discussion we're
an
having. We
option
can't
of
say,
like,
Let's go to deliberative session.
of an
and talk about
executive
whether-
session, if you had to do that. Again, I'm not sure.
Yeah, executive session would be the only one.
This is very much
Yeah.
out of my head, just trying
In
to
real
put
time.
something together. that
I would
makes sense.
suggest taking that out.
Especially if it's the
Unless you
whole
have a
point of it
real.
is conflict.
No, I'd run it by the attorney.
Yeah,
This is kind of, this is just a
Yeah.
start a conversation about,
Right.
is,
Yeah.
did you want to do something like this? If that's the wrong vehicle, then it's the wrong vehicle. But that's why
No, I think.
I'm just seeing if you guys are
I
even
think that's-
interested in it. That's all.
I
So-
think that's right, because if we're talking about whether somebody has a conflict of interest and then we go into a deliberative session and come out and say, oh, we actually discussed it, he doesn't.
Yeah, doesn't look, I mean, at a minimum, that doesn't look good, right? Like.
I mean, I could always change it to say that
It's-
we deliberate in public about it.
It's almost 8:30 and we would like to go into deliberative session tonight, so.
Yeah, I'm almost done. So I got a couple quick comments.
Okay.
So the minutes auto approving, I don't know if that's legal, you can run that by the lawyer. And then specifically thinking about how you want members of the public to request changes to the minutes. Like, do they just come and make a public comment? Do they submit to you? Like, just, well, spelling out how a member of the public does that.
You ever had a member of the public come?
Yeah, I've had a couple. Typically I've done it once. I've just kind of gone back in and most of the time, I think Bradley Brave one, like I forgot to change the date on one, and there was another one, for whatever reason, when I cleared who was there. I didn't add them back in, but if you go back and watch the video, they actually were there and participated. So I just my own admission, when I
Right.
drafted it, because sometimes who was there varied, so sometimes if I was, depending on what old set of minutes I was using,
I think
it was a drafting error.
question.
Yeah.
We keep moving.
Yeah, so just one last thing. So, and then beyond what's required by Vermont swimming law, just moving past like actual requirement. I do want to encourage you to include guidelines on how you want to engage with the public, like what your choices of what you want to see in terms of public engagement. I get that the hearings are typically really between you and the applicant. But I do think there's value in encouraging public input that informs your review. And my experience with this DRB has been that you don't really value input from the public, and I'd like to see that changing. So I think thinking about how you want to.
I think that's incorrect. I think
I
that we,
strongly disagree
I
with you.
disagree with you on that
I
one.
do value what comes.
I just-
And we look for that.
Yes, that's his perception though.
Right, exactly. I think it's,
I'm telling you what my perception is. I've been sitting here for 10 years too.
Okay.
I
Yeah.
think that speaking for myself, and I think for other members here, that we encourage public opinion
Okay.
and we encourage public participation. What we don't encourage is 10 people saying the same thing, just to hear themselves talk or to continue to make the same point.
That's not been my experience, so.
Well, I'm just saying that this is what we try to accomplish, Bradley,
Okay.
and we certainly don't discourage public opinion.
I-
We like to hear from people that are adjacent landowners and what they think, because often we are dealing only with an applicant and we only have his opinion. And then our fear is somebody's gonna drop out of space and say, I didn't get a chance to talk about this.
Well, Mark Fossil was a point of that, like he came in and participated.
I'm just saying that I think that you might have had an experience where you got this perception, but I think that speaking for all of us, I can say that we would like to see people
Okay.
come to these meetings and give us comments briefly.
Okay, so to bring it back to the point, I would say that then I would encourage you to do things in the guidelines that spell out how you want to see that engagement look, right? So that's all.
I would add on, I think we gotta, take the feedback. There's our perception and there's the public's perception. On the point of hearing multiple people say the same thing, I wonder, how do those individuals establish party status? if
I was
they
just
don't
thinking
propose
of
those
that
comments?
myself.
We can't say, we heard this before, well, then they don't get the opportunity to say it.
Right.
We don't
Maybe
really-
you
we
could
don't really-
say it's like, are these,
I think we have to be careful about
Hmm.
saying that we don't want to hear the same thing more than once. We can limit it time-wise if it's gonna take too long, but we don't know what someone's point's gonna be until they're done.
Okay, I agree that we can limit it time-wise.
I don't think we should
I don't
limit-
think we should cut anybody off, but by the same token, we should be able to say, well, we've heard this before, do you have anything new to add?
Yeah, but I also think there's also weight to having comments from more than one person.
on the same
If someone
topic?
comes in and says, I don't like this project because of whatever, and we say, okay, well, one person said that. If 40 come in, then it's sort of like, okay, that's kind of valid. Yeah, I just don't, I think we have to be very careful there.
And
maybe if it's clear-
I've never said that we should not hear somebody. What I'm saying is that we shouldn't have to hear the same thing over and over again. So if someone is repeating what has already been said, we need to be able to say, well, we already heard that. Do you have anything new?
Well, and I think this is maybe what you're saying too, is even if maybe there are 5 people that want to say the same thing, and I think we need to at least hear them say, I agree with what,
Okay, but they only have 3 minutes.
or
Okay.
less.
I just
I
think-
mean,
I think this-
I think announcing
minutes.
themselves and saying, I'm another person in that camp.
Yeah,
I mean, if
Winooski
someone's-
gives you a timer. They give you like, depending on what it is, a minute
I
or.
also think it's very infrequent that we run into those situations, and I think if someone's gonna come here, even if, I just think we have to err on the side of hearing it. Just my 2 cents.
Yeah, I mean, I do
Within
think
reason
there's something that you
timelines.
guys could do is like, if you keep hearing the same thing, like you hear 2 or 3 people say the same thing, you could be like, does anybody else have feelings that are similar to this?
Figure that out.
And then
We'll
you
figure
can
that
kind
out.
of,
Well, that's what
That
I mean,
way.
it's like acknowledging, we don't want to like just say, okay, everybody here feels the same way,
yeah, but you don't want
So you're gonna
5 hour
talk
meetings
for
for
everybody.
each thing either.
where somebody, like, to your point, they might want to become an official interested party and have their.
How do we actually define an interested party? I've always kind of been interested, like,
There's an actual definition. It's
Is there-
defined in it.
yeah,
There's an actual-
I think if you're a.
How do you
a budding
determine it,
landowner,
though?
you're on-
that's.
That's
So the ultimate determination
Sorry, Brad,
is
did
whether
you
the
did you have
court
more?
will accept them.
Oh, that was it. No, I'm done.
Okay.
Thank you.
Okay.
Appreciate it. Thank
Okay.
But under the statute, they have to
If I do get stuff
offer
in writing, I usually
written
take
or
it
oral
pretty
evidence
seriously.
at a hearing.
Okay. And yeah, obviously I knew the landowners were the obvious ones, but it was,
Right.
or the abutting landowners were obvious ones, but.
That's automatic, yeah.
So what would you, so I kind of got a little bit of some guidance from making some changes here, like those are kind of going back, like maybe obviously the requiring somebody to recuse themselves kind of thing that needs, is that something you, it sounds like you're interested in it. I need to do more work and figure out
Well,
whether or not.
what I would
it's legal.
suggest is you take our comments, filter them into your draft here, and then before you come back to us with
Run
it,
by the attorney.
run it by your attorney.
Yeah, that's kind of what I was thinking I was gonna do. Before I would bring it back for you guys to look at again. So
Good.
is that kind of, do you guys want to make a motion to that effect? If that's what you would like
No,
me to
just
do?
do it.
Just do it.
It might be cleaner if we have a motion to do it.
Is this an official act?
I mean, it's other business. If you guys are at, I don't know, because you're directing me to do it.
Can I recuse myself from this vote?
No.
Well, then, how about this? I guess we'll roll the dice on this and then I will take your direction and say that's what I'm gonna do right before I bring it back to you guys. Is
Good.
got your comments, Bradley's comments. If you want to send anything to me in writing too, I'm happy to take it into consideration.
Yeah.
When I draft it. So.
So Tyler, this was an easy stuff, so thank you. Nice. I
Yeah.
know this was your first take at it, so.
Yeah,
thank
and
you-
again, this
thank
was
you, Bradley.
thank you for bearing with me. with
Not
the
easy stuff at all.
Yeah.
there in terms of
Absolutely.
like trying to like, to Bradley's point, or how do we deal with conflicts that come up in the meeting so people aren't like appealing things or doing stuff because they thought there was a conflict of interest or there wasn't, we can address it. We have some system to address it ahead of time.
I have one question on it all, and not to flog this too hard, but, so let's say we take a vote and someone there was concern about whether one of us had a conflict of interest and we decided, no, we don't. And we vote, and then it's later determined that in fact, that individual did have a conflict. What, does that vote just get changed?
I
Does the
think
whole
that's what I
decision
don't- that's-
Go out. the
I don't
board?
know, you know,
I
that's,
mean,
there's a lot
Is
of
that
unknowns
ever
there.
gonna happen in our careers? I don't think it's worth worrying about. It
I mean, based on
could
the
happen.
world outside of us, it seems like what happens is nothing. And it's just a footnote saying.
I think the world outside isn't a good measure.
Well, that's part of the problem with this is like you have stuff, it's very vague, there's no enforcement, it's just a lot of like, what are we,
Well, I
what are we
think,
doing?
I think upon appeal of a decision, it would matter.
True, that's true.
And I think if it changed the outcome of a vote, I suppose we could always just reconsider
And
it.
I think that's why. we'll
Well,
have
but the
to-
appeals
appeals.
are de novo appeals, so.
Yeah, we
Doesn't
wouldn't
even
even do with it.
Yeah, we
Right.
would have to, in order to have ours not be de novo, would
Grounds
require
for-
a lot more
I think
legwork.
we grounds for appeal.
I was gonna say, could a conflict of.
Then
could
the
a
minutes
perceived
would be
conflict
transcribed.
of interest be
You need a
grounds
video
for
of
appeal?
the meeting.
Because I just try and capture the
Unless
flavor
the
of
one
what's
vote-
going on. It's not a transcript. It's not intended to be.
Okay,
Motion to adjourn to deliberative?
yep,
Who wants to, whose motion is it?
I move.
Roger.
I'll second.
all in favor?
Aye.
Aye. Thank you guys for your
Thank you.
input.
Good night.
Really appreciate it.